Hello, so good afternoon, everyone. It's a pleasure to have you here. My name is Iluezi-Ogbaudu. I am the Interim Coordinator and Secretary at Justice Reform Project. I'm one of the co-organizers of this Open Conversation series. Our co-organizer is the Integrity Organisation Ltd by Guarantee, and together we just on track to engage with the public to share views on our justice sector. As you may have noted, the theme is present a question which says, is the justice sector fit for purpose? We really would like to discuss this over the next couple months from different perspectives. For today's edition, which is the first edition, and which we are pleased to have you join us on, we are considering this question from the business sector perspective. And we have so distinguished speakers and panelists here with us to discuss this interesting theme. So I'd just like to formally introduce you to this event and to say that we hope that you enjoy it as much as we have enjoyed putting it together for you. Just to check all the boxes, we are recording this event, and once the event is done, we'll upload it on our YouTube for people to come back and watch. And before I go on, I'd like to appreciate everyone present. I'd like to greet, which I should have done initially, I apologize. I'd like to recognize my Lord Justice Olubunmi Oyewole of the Court of Appeal present. The Lordship, is a pleasure to have you. His Lordship will be speaking during the panel sessions. I'd like to acknowledge the presence of Mr. Osaro Ehobane, Senior Advocate of Nigeria, who is a member of the JRP's management team. I'd like to recognize the presence of Mrs. Olumfuke Adekoya, who just joined. She's the chairman of the Justice Reform Project. I'd like to recognize our speakers. Okay, first, Mr. Olusoji Apampa, who heads Integrity, our partner organization, and who is also a member of JRP. And our speakers, Alhaji Tijjani Borodo, who is our keynote speaker. Welcome, sir. It's good to have you. And good to finally see you.
My pleasure.
Thank you very much. Then our panelists, mentioned by Lord Justice Olubunmi Oyewole, Mrs. Ayotola Jagun, who is the company secretary of OANDO. I'm happy to have you, Ma. We had spoken to some degree before today. I'd also like to welcome Mr. Babajide Ogundipe, who is a member of JRP, and who's going to be speaking during panel sessions, and everyone present, ladies and gentlemen. So thank you for coming. Without further ado, I would now invite Alhaji Tijjani Borodo to deliver his address. We called it a keynote, but it's not really a keynote. It's just an address to set the conversation going. So thank you very much, sir, for having us. We can't wait to hear from you. Thank you.
Thank you, distinguished ladies and gentlemen. Can you hear me clearly?
Yes, I can hear you, and I'm sure they
everybody can hear me. Thank you very much. The coordinator for JRC. It's an honor and a privilege to be part of this. When I was contacted by the MD of Prosha, I said I didn't think I was the right person to make these opening comments or remarks or whatever we call. And she encouraged me and said that it's something that I can do. I accepted to do this because I've seen that this is a new initiative, and I think it's a very good initiative, and I'm pleased to be part of it. So pardon whatever I'm going to put down here if it doesn't meet your expectations, but let's see how it goes. I spent a lot of robust discussion during the panel discussions. I've seen a couple of names which I'm familiar with, so I can say I'm in a terrain I'm used to. Now, I have some keynote address, which will honestly be a keynote address, but let me just read out what I have, and I hope I'll be able to talk or address some of the issues that we're supposed to be discussing here. And I say is that, what I say is that it's an open conversation series by Justice Reform Project, keynote address by Alhaji Tijjani and Borodo, fellow Institute of Directors, on the theme, is the justice sector fit for purpose? Courts, a business sector perspective, delivered today, Friday, 30th July, 2021. The chairman of occasion, distinguished guests, friends and participants, gentlemen of place, ladies and gentlemen. First, let me express my profound appreciation to the organizers of this event for the kind invitation to participate in this important national conversation. I'm indeed proud to be associated with this fine group of patriotic and passionate Nigerians who have built this coalition into what it is today. It's a great pleasure to speak to an audience of people who are tirelessly committed to justice reform in Nigeria through legislative and policy advocacy. The theme of the conversation is the justice sector fit for purpose, a business sector perspective. It's very timely and germane, as available research has shown that an effective and efficient justice system is essential to sustain economic growth. Nigeria, one of Africa's major economies, is of great interest to foreign investors from both inside and outside of Africa. Rich in natural resources and with an increasing diversifying economy, Nigeria offers a sophisticated legal market and a very active dispute landscape. Yet, despite the abundance of these resources, our judicial system, often beleaguered with slow and costly court proceedings, have discouraged investors from choosing litigation to solve their disputes. As a result of increasingly competitive business climate, with a focus on operational excellence, sustained substantial profitability, businesses have a growing preference for processes and systems that provide platform for rapid decisions and dispute procedures that support rather than undermine business and customer relationships. The popular phrase, time is money, cannot be overemphasized. No investor is keen to tie down money, capital or investment for an unascertainable period due to commercial disputes. The fear of times is that the investment and or capital will have lost its value at the time the dispute is eventually resolved. Thus, investors will be advised to investing funds in any country where dispute resolution is not reliable, effective, and or efficient. The judiciary is ideally regarded as the bastion of hope for the common man, considering the lofty responsibilities of justice dispensation assigned to it by the society. However, this critical goals of the judiciary, the judicial process is often painstakingly slow and leaves much to be desired. For the private sector, the general impression of the courts in Nigeria is that small businesses see it as a waste of time. Big businesses see it as an unfortunate but necessary evil. Generally, most business owners will rather exhaust all other options and only go to court as a last resort. Recently, the judicial workers were on strike for months and created judicial vacuum, which was not attractive to business owners, nor to the generality of the society. This has further driven a culture among businessmen that the courts should be avoided as much as practicable. In a functional society, the courts are to administer justice as efficiently and effectively as possible because it inspires public confidence in the judicial process. A judicial system that is bogged down by delay and inefficiency soon loses credibility, resulting in fewer and fewer people patronizing it. And that could be the highway to self-help and anarchy. An effective and efficient judicial system is indispensable to business activities and society as a whole. Judicial efficacy measured by trial length is one of the essential factors in the effectiveness of the justice system and ensure contract enforcement, which is the basis of market transactions. Judicial efficacy also closely associated with accessibility to judicial services, and the certainty of an efficient judicial system raises people's confidence. Two major undercurrents are leading to this growing preference for non-traditional court system. The first relates to the dissatisfaction with the costs, delays, and uncertain outcomes of the litigation system. The second relates to a deeper social transformation involving our search for systems which can adequately match the speed, responsiveness, customer orientation, and globalization of businesses and technological change. I recognize that in recent times, there has been considerable drive to reform the courts and our processes and make them more efficient and adaptable to the demands of parties. For instance, the Evidence Act 2011 provides for the admissibility of computer-generated evidence. Some courts of records in this country have also made rules of procedure containing provisions enabling electronic filing, electronic service of court process, and even limited form of virtual hearing. I must also applaud some Nigerian courts, notably the High Courts of Lagos State, FCT, Ogun State, Borno State, etc., and National Industrial Court, which issued practice direction that allow for the conduct of limited court businesses via online platforms such as Zoom, Microsoft Teams, Skype, etc., notwithstanding the evaluation of its functionality by some stakeholders. I also note that many Nigerian courts have implemented the fast-track routes for high-value disputes, a motive that has been embraced by many foreign investors and businesses who have no option for resolving their disputes. While I appreciate that some considerable progress has been made in tackling these gaps and inefficiencies, nevertheless, despite the increased use of technology in court proceedings, in many jurisdictions, some courts are yet to embrace this innovation. This has increased the backlog of cases in those jurisdictions and made litigants believe more in ADR mechanisms, especially mediation and arbitration, to promptly resolve their issues. Sometimes we find that parties to contracts are not adverse to breaching contracts, knowing that the aggrieved party would be reluctant to litigate because it would take too long and the cost unprofitable for his discounted cash flow. I believe that there's an opportunity for our judiciary to invent itself, join the League of Attractive Jurisdictions for Commercial Disputes, and thus become an enabler of the country's economic recovery and expansion moving forward. While there are probably many things that could be done to trigger this transition, a few critical areas readily come to mind. One, reform legal frameworks for justice system, including commercial, criminal, and procedural codes, engineering processes to improve workflow efficiency, cut backlogs, and reduce opportunities for corruption. Two, improve case management systems. Three, strengthen human resources and financial management of information systems. Four, invest in court infrastructure and ICT to improve access, efficiency, and transparency. Five, build capacity through training and pair exchange. Six, review whether the existing legal and institutional framework adequately provides for judicial performance management and measurement. Seven, expand the numerical strength of judicial officers and overhaul the entire compensation package. 8, establishing a credible compliance system. 9, strengthening the concept of court-connected ADR facilities, etc., etc. Recently, I saw the Honourable Attorney General of the Federation on the telly showing a system that is being programmed so that we have them in our courts to show that judges do not really have to be taking down their nose hand with long hand. There will be a system that will convert lots and lots of presentations by counsel in court to typewritten documents for judges. I think this is a very good innovation. If you put that, it will give our judges the opportunity to clearly listen to arguments for counsel being presented before them so that they have a near accurate proceedings aided by technology. Now, I don't need to tell this audience that the role of judges and judiciary is paramount in installing public and international confidence in the legal system and rule of law. The role of the judiciary in the 21st century shows that courts are increasingly required to be dynamic and responsive to economic, social, technological, and ecological challenges. This is reflected in increasingly complex legal cases as economies diversify, technology brings us closer together, and the demands on our time become greater. Perhaps it is this aspect of the judiciary that has require the most significant adjustment, both in the role of judges and also development of judicial capabilities. Ladies and gentlemen, let me conclude by stating that empirical evidence has shown that improved judicial capabilities can also generate greater international confidence by assuring foreign investors that investments are safe and their property rights will be held up by courts of law if challenged, as well as providing credibility that the national legal system respects and protects intrinsic human rights. It is therefore very important for judicial capacity to be continually developed through continuing education, training, international exposure, cross-country dialogue, and information exchange. Finally, I thank you very much and most sincerely for the opportunity to share my thoughts on this very important topic. To me, the ultimate goal is judicial reform, and I look forward to fruitful conversation on how this can best be achieved to improve our business climate in the country. Ladies and gentlemen, once more, thank you for listening to me.
Thank you so much, Alhaji Borodo. We're very, very grateful for that precise and very precise, but I mean, poignant and delivery. And we were very grateful for that. Listening to your speech, I cannot but agree with, I mean, the areas you identified as the gains, the developments that have been made, notwithstanding the general view that many members of the public take. And, you know, the criticisms that have come in relation to the effect of an inefficient judicial system on the public. The commendation for the courts is very impressive. I do recall that in one of our previous events, we had Justice Zana of the High Court of Borno State come and share with us the work that was being done, and it was remarkable to see just how much had gotten into it. Our hope and our sincere wish is to get as much of this development down and across the country, and to even improve on what has been done. Without wasting too much time, I would like to introduce our panelists so we can get straight to the panel discussions. Just take their views on some issues that we've picked up from Alhaji Borodo's address before we then go to the audience. It's an open conversation, so who wants to get the views from our expert panelists, then we go to the audience to share their views as well. So I'd like to welcome my Lord Justice Olubunmi Oyewole, the Court of Appeal. My Lord, it's a pleasure to have you here with us, and we're happy to have you share your views on some of these issues. I mean, it's important for us that we have you here because from our previous interactions, we do note that there's a lot that we don't get to see on this side, particularly in relation to the work that's being done. And we look forward to having you share this with us. Welcome, Your Lordship.
Thank you, operator.
Thank you very much, Your Lordship. Next up, we have Mrs. Ayotola Jagun. Ms. Ayotola Jagun is the company secretary at OANDO. It was important for us to have somebody of her capacity and standing because, I mean, OANDO is a major player in perhaps Nigeria's foremost business sector for the past, I mean, since oil was discovered. So we're happy to hear from you, ma'am. We're happy to have you. She's a lawyer herself, so I mean, it'll be good to share this passionate views on the topic. We also have our very own Mr. Babajide Ogundipe, who is a partner at Sofunde, Osakwe, Belgore, and Ogundipe. Sofunde, Osakwe, Ogundipe, and Belgore. He's a member of JRP. His brilliant and precise views are views that we appreciate and views that we think we should have on a subject like this. We're supposed to have Mr. Oluwadare from SERAP on the call, but I haven't been able to reach him. If he does join us, then we'll get to him. We decided to have SERAP on because SERAP is a major user of the court system. I'm not sure there's a day when I pick up my phone and I don't see that SERAP has filed a new action. So we feel that if we get SERAP's view, it would be good to have him tell. Okay, Mr. Oluwadare has joined us. Mr. Oluwadare, welcome to the program.
Thank you very much, Mr. Femina.
Okay. They call them Amis in Yoruba language. The Amis in your name didn't let me catch you on my participant search. So welcome. It's good to have you. So very quickly, we're just going to go straight into the issues that were raised by our keynote. We'll call him a keynote until we figure out what to call the address as we continue the series. But I think we're going to start with SERAP, since SERAP is, like I said, a major user. So we'll just ask Mr. Oluwadare to share SERAP's experiences in using the justice system. We noticed that you have a lot of cases, fundamental rights enforcement actions, and social cases really. So in your view, very short view, what would you say is your experience, and what do you take away from the keynote that you agree with, that you want to highlight, and you don't agree with? Mr. Oluwadare, can you hear me? Unfortunately.
Okay, I can hear you. Okay. Sorry, I got disconnected.
Okay. So did you hear my question, or do I repeat it?
No, I didn't get your question. Okay, you would have to repeat it. I'm sorry.
My apologies, no problem. So I really was just asking you to share SERAP's experiences, with the justice sector, since you do a lot of, you interact with the sector a lot, particularly the courts. So what would you say are the major gains? What would you say are the major drawbacks over the years? And how would you summarize your experience, with the courts in a nutshell?
Thank you very much, Mr. Femina. And I'd like to appreciate the JRP for this opportunity, and also for the eminent members of the panel and even people that I've seen as participants at this meeting. But I think a nutshell would not be enough to capture what will be, in my view, our interesting experience so far with the judiciary as SERAP. I must start by pointing out that Alhaji Borodo did make a very fine point. He captured in essence what has been the past, the present, and even the future of the judiciary in Nigeria. But we must say that this all, I think, starts with legal education. The bench is from the bar, of course, and the policymakers and the implementers are members of the bar. So really, and that is why education is where it should start from, including the understanding the essence of businesses and civic space. So having said that, going to our experience as SERAP, we can start with filing, for instance. Manual filing system is just outdated. Every lawyer complains about it, including the new wigs, but it's just, there's no end in sight for these particular problems. We can see the TSA and the remitter system is laudable, really, but you would understand that its implementation would appear that the policymakers, much like what we've seen in Nigeria, just overlook some very obvious things. For instance, as simple as getting pay points close to the registry, really, that's simple enough. Even having a printer with powered up system. So at the Federal High Court Lagos, when you are assessed, which is manual anyway, you have to get out of the High Court premises, cross the road into the car park, where someone had been business-minded enough to have some kind of, call it makeshift computer center, where you assess remitter, and then you print and you come back. Otherwise, you would have to go to Falomo, which is about 2 kilometers, to line up with others on the queue to get paid. And then you can just imagine the problem of filing. And so that is one thing that we need to talk about. And then you can talk about case file management. The movement of case file from the registry to the court is something I'm sure a lawyer wearing a suit and tie would not want to face, particularly on a sunny afternoon, Friday afternoon. You don't want to go through that stress. And then you ask, should this still be manual at this stage, particularly with the lessons of COVID-19? Yeah, but that is still what we see that we go through. Even in Lagos, where incidentally or ironically, we see the commercial fast track. Every time I see that, it looks to me like it's a paradox, commercial fast track. It's neither fast, either in the movement of the file to the registry or even in the court itself, but yet it's still called commercial fast track. And bear in mind that Lagos is one of, possibly the best system in the country. And then we go to case scheduling, and that is what I call that in my own advocacy is a courtroom administration. And of course, we see what I saw too, as Alhaji Borodo had mentioned, the latest launch by the Vice President about the application that would ensure the judges don't write in longhand. But that's not the first time. We've seen that in Lagos High Courts. There were stenographers, I used to see them in the Lagos High Court with special machines, but it's just fizzled out. And then we don't see that. But talking about courtroom administration itself, it's about the handling of the court by the judge. And I must say, we have fine, intelligent judges in Nigeria, right, across all the courts. But it would seem that that ability to manage the court, the administration side, is really lacking. And so why would we have two lawyers argue back and forth for 35 minutes, taking a date to hear a motion for extension of time? Remember, not that day, they're taking a date to move a motion for extension of time, and then they would argue for 35 minutes about the convenience of the date. That's not administration. That's not good administration, I dare say. And so it would mean that the judge would be able to manage time. And this speaks to allocation of time and specific dates for specific matters. Again, Lagos will take the lead in this. I've seen judges allocate days for CMC, what is called case management conference, allocate dates for even arguments, or to take trials, and give specific times. I've seen some judges do that, but this is rather individual innovations of the judges, rather than being a rule or a norm from the administrative, from the CJ. And so that has been the experience too. And not to talk about the federal courts in Lagos. The buildings, as we all know, the inadequacy of the building. And then I have colleagues in the office who dread, so they would rather take up a case in Abuja and take that long journey than go to Lagos for a case, because they would end up staying till 5. A colleague of mine, a lady, left court, I think 6. I won't mention the name of the judge, and the matter wasn't heard. And so the question is, couldn't she have been told by 9 or 10 that her matter wouldn't go on, and then she would have left and done something otherwise more productive? And I think this is where we need to understand that legal knowledge is different from that administrative skill that members of the bench need to learn. But again, I think this stems from what we learned or did not learn in law school. And so why can't we take course applications, for instance, in chambers? Again, we've seen this as innovations from individual judges who are excellent, but why can't we have this as a norm? And I've always seen that work well, talking about Order 9 at the Court of Appeal in Lagos, where the notice of non-contention is taken even in your absence, and then because you filed a notice, and that works. And then thirdly, in my experience, I would like to talk about the uncertainty, or what I call this gray areas in administrative procedures in the court. So we still have judges of the Federal Court interpreting out of jurisdiction in Order 6 of the Federal Court rules to mean out of Lagos or out of Abuja. And so, and really, do we need the Supreme Court to pronounce on this time and again to understand that out of jurisdiction? So we need to have this certainty on matters of procedure that does not make a judge, for instance, interpret a motion when your default fields start counting, for instance. And I've seen this happen in court, saying that default fields will only stop counting when your application for computation is approved. And then you wonder, and then it turns to a long argument in court. These are innocent, these are simple matters of procedure that really would help to make sure the law itself is certain. And again, there is this practice and procedure that I've seen, particularly at the Federal High Court, where urgent matters during vacation, like we're here now, are limited to fundamental right cases. And really, I've not seen anything written in that regard. It just appears the rule of the thumb that judges make in the courtroom. And then we lawyers, we parrot as the court pleases, without even trying to examine the basis for these rules. Who made them? Why? And why can't we have them changed? And then fourth, I'll go to the quality of decisions. And I would like to point out that quality can only be rated, to my mind, on the advancement of jurisprudence and in line with the judgment, international best practice, and the socioeconomic realities of each location. So I wouldn't fall into the error of lawyers who, for instance, grant interviews and label a judgment of court that is not in their favor as being low in quality. No, but of course, we all know that the ratio of the court is defensible as long as it's rooted in law. But for context, we need to understand that quality is rooted in the socioeconomic realities of that locality of the court, and of course, the international community and what the law ought to be. And for context, I would like to point out, for instance, in Nigeria, it's quite ironical that given our religious and moral fervor, we would see that, and the view that we have of Western societies, that for instance, in the US, they are much more particular and concerned about whoever gets to sit on the Supreme Court. And for a society that we label as being liberal and being free, because they understand the importance of whoever sits there, the power he or she has over the moral compass and what you term moral compass and the socioeconomic benefits and even the economy of the country. I doubt if we understand that enough here, given quota system and all the other things that come into play. And that is why you see the quality, not quality as in legal knowledge. I'm not talking of that. Quality as it does it reflect the realities that we see in our society. And perhaps, in fact, the example will be seen in that of cost. How would the Supreme Court, for instance, grant cost of 50,000 after 12 years of rigorous litigation at the Supreme Court, even at the Court of Appeal? It makes it appear like that the bench does not understand the realities of what we're going through. And in this instance, cost is not punitive. It is basically restorative. And be captured by frameworks like the UNCAC that Nigeria have signed on to. And again, ultimately, what we've seen as public interest. For what we do as SERAP, we file a lot of public interest cases. Presently, we have more than 39 cases covering the Federal High Court and the ECOWAS Court. And I must point out, I must praise the ECOWAS Court for its virtual proceedings. Yeah, there are technical glitches, but it has shown beyond a doubt that virtual proceedings can work. And why would we have someone going to court to even question whether it can work in the first place? And so we've seen us in courts arguing with the courts as to what is public interest. And so it's surprising that in the 21st century, you are arguing before the court and trying to explain yourself why climate change, for instance, is public interest. The sky is above everyone else. So if it rains, if the sun shines, of course, everybody should feel it. And to me, that's just explanatory enough. And that shows the peculiarity of our jurisprudence and the quality of the judgments. So I would, as a member of the judiciary myself, I would say that there's been a lot of progress. There is still more to be done. But I think the basis of that progress needs to be understood so that we are not making progress that is superficial, but does not reflect on the socioeconomic lives of the people, particularly the business community economy that we are talking about. Thank you very much, Mr. Femina.
Thank you, Mr. Oluwadare. Spoken like a true user of the justice system, even from the filing and going to Falomo and going outside the Federal High Court. Even I can relate, haven't been there, I mean, for the past, haven't practiced in that court past months. Okay, so we've heard from the user. We're going to turn to Mr. Ogundipe. And I mean, Mr. Ogundipe is the foremost commercial lawyer. He runs the foremost commercial law firm and specializes in the commercial dispute resolution. So I think the question really that we would like to ask Mr. Ogundipe is similar to Mr. Oluwadare's question, but it's more from a client's perspective. So I really would say that, how would you say that the clients see the justice sector, the court system, particularly across the last maybe 1 to 2 years? I mean, if you say 1 year, we know exactly where we're getting to, but let's say 1, 2, 3 years. So Mr. Ogundipe, can you please just, could you please share with us how you, from a client's perspective, how they would view the justice system in the past years?
Right. Thank you, Femina. First of all, I'd like to say payment is on the way. For having said all those things about me, they're not true, but they're nice to hear all the same. I see myself these days as someone who used to be an active litigator. I used to be an advocate in court. I rarely go to court these days, and that's been the position for at least 3 or 4 years, or possibly even longer. But I do still get involved in the practice. I draft pleadings, I review what my colleagues do, and I hear stories about what goes on in the court. This to be addressing the issue of whether the justice sector is fit for purpose as viewed from the perspective of commercial clients. The fact of the matter is that the simple answer to the question is that the justice sector in Nigeria is not. I think there are very many people who would argue that. Now, you have to look at or try to understand why people would come to that conclusion. And our keynote speaker, he appeared to on the judiciary, and I'm pausing because I'm getting a message that my internet connection is unstable. From my perspective, I view the justice sector as being inclusive of everything. First of all, it's made up of all three branches of the government. The executive are involved, but it also involves state and non-state actors, and it can criminal and the civil justice systems. From a commercial client's perspective, the solution to what they're interested in is economic, in the sense that the first thing they want to know is how long, or rather how much would it cost to get a resolution using the and how long will it take? How long it takes is also linked to the cost. In Nigeria, the actual costs of engaging the legal system isn't very high. That is, in terms of the money that you spend, it's not very high. But what you will pay will be of engaging counsel. This varies according to who you engage, how they charge. But also, it's also involves other things, such as that it takes, in the sense, as Alhaji Borodo mentioned, the time that it takes reduces the value of whatever it is that you're trying to achieve, especially now. At the beginning of this week, you know that market for
Mr. Ogundipe, I'm sorry to interrupt you. I'm getting feedback that the audience can't hear you very well. So what I would suggest is, if we don't have an alternative on your end, maybe we could take you without the video. I mean,
surprisingly, I can hear him very, very clearly.
Very clearly?
Very, very clearly.
Okay, all right.
Who said that?
Okay, so let's press on then. Apologies for the interruption.
I can hear him well as well.
All right,
okay.
Fantastic. All right.
Same here.
I lost my train of thought a little, but I was talking about, I think I was talking about how time erodes the value of the dispute. And the solution, to my mind, to problems, the last speaker identified many of them, is not, again, something that one needs to have the judiciary deal with. It's something that's all-encompassing. In terms of, let's take something that Alhaji Borodo suggested. He spoke about increasing the number of courts, increasing the number of judges, and things of that nature. But the first thing that one needs to think about along those lines is, how much is it going to cost? And this is something that we need to understand in Nigeria, is that we call on government to do this, to do that, and to do everything else like that. But the truth is, Nigeria is not a rich country. In terms of global economics, it's a low to medium income country. So we have to deal with the reality of what we have. So how much is it going to cost, right? studies of that nature need to be done. And it doesn't help anyone if this is the problem, this is the problem, this is the problem, and we don't look at the problem and try and see how we can find a resolution within our means. And I could go on, and I don't want to, because I would be essentially repeating what Alhaji Borodo said, what Mr. Oluwadare said. But I think that the last thing I would like to say here is something that Mr. Oluwadare touched on as well. It relates to the quality of the work that's put out by the courts by way of decisions. Now, the problem from my perspective is that in the last 10 to 15 years, Nigerian legal practice has descended to being something that's focused not on substantive law, but on procedural law. The first thing you have to do is to worry about whether someone's going to come and say that the court has, you're out of time, you can't do this because of some procedural issue. And they forget that their function is to administer justice according to the law. And wherever there's an opportunity to do justice, they should move in that direction, and not, as I fear they've been doing, to just embrace things like the person who signed is not a legal practitioner, and therefore every years ago becomes invalid and totally null. That's, when you have a justice system that encourages that sort of approach to dealing with legal problems, anybody any justice. So I'll stop there, Femina. I mean, as I said, I could go on and on, but it'll just be repetition, and I don't want to repeat myself. Sound like the old man that I am.
Thank you, Mr. Ogundipe. Thank you so much. We'll just very quickly move to Mrs. Ayotola Jagun. I mean, the question is really clear. Like I said before, OANDO is a major player in an industry that's been Nigeria's most lucrative for as far as we've known it, So I'll just say, like, with how high the stakes are in that industry, just how do you approach the question of disputes, the question of justice, the question of the courts coming up? Just how do you view that? How confident are you in our court system? What are your concerns? What are the gains? What are the drawbacks?
Thank you very much, Efemina, and thank you for having me as well. Really honored to be part of this discussion. The last time I was in court was probably 21, 22 years ago, as a legal practitioner. And in terms of practice, active practice, what astounds me is that when I've had to be in court lately from the perspective of an in-house counsel, and so with my lawyer, as a client of my lawyer, how, from my perspective, very little has changed. In fact, sometimes I find that I have to call ahead to check and ensure that the matter will go on before either getting on the train to go all the way to Ibadan or getting out of my home or my office to go to the court. So in terms of efficiency, we still struggle with the same issues that I see we had, 21 to 6 years ago when I started. Massive improvements in Lagos State, but it's for us, it's a question more of efficiency. And I know that I'm just wanting to address one of the comments made about, do we have more courts? Well, if we have more courts, then we need more registrars and more judiciary staff to. It's not really so much in the number of courts, it's really about efficiency. And it's about efficiency all across the board. I also would not lay the blame solely at the feet of the judiciary. I would say that lawyers also have a large part to play in making the judicial system a lot more efficient. When we talk about frivolous applications, when we talk about focus on procedure rather than substance, a lot of that is coming from the applications that are being made in the courts, and not necessarily from the judicial system in terms of the bench per se. And so I feel that a lot of change has to happen. Now, from a corporate perspective, you know, we have very complex transactions, which are also very, in terms of value, very high value, very complex transactions, which have to be completed within a certain time frame, based also on our corporate strategy and just so many other parameters. When we talk about also our international, a lot of these contracts, a lot of these transactions are international in nature. And so when we are looking at either foreign investment, whether it's equity, whether it's debt, we're talking to bankers who want to be clear that if there is a dispute, they can easily enforce. And so certain things that are important to them in terms of due diligence are going to be our judicial system. And of course, to mitigate the fact that there is a little bit of concern about the effectiveness and the efficiency of the Nigerian judicial system, we're being forced to include in contracts certain terms which either, first of all, make the cost of the transaction even more expensive, but secondly mean that we have to submit to a foreign jurisdiction in some cases, and we have to submit also to, you know, then therefore a foreign court system. And we're also having to submit also to alternative dispute resolutions like arbitration, which is more efficient, much faster. And so that is a big concern for us. It's a concern also because as a Nigerian company, an indigenous company, you want to plug into, you know, the system. You want the system to work better because, you know, you're local to it. It's going to favor you. And in the same way, you are actually helping to build the economy, to build the judiciary, to build the judicial system, and to build the systems of government that are around you. And that's something that we are certainly very concerned about. So efficiency is one thing that is key for us. Access to justice is key as well. Being able to ensure that, you know, when we need to go to court, I mean, somebody mentioned the COVID-19 and the Jagun strike as well, and the fact that for effectively 2 months, we could not file processes. We could not proceed with some of the litigation that we had in court. In other jurisdictions, I mean, those type of things would have been taken care of. And I know that this was a political, in quotes, a dispute of sorts that kind of spilled over, but it has an impact, and it has a great impact and an effect on the business world, and certainly on how attractive Nigeria therefore is. And ultimately, like I mentioned, the cost of transactions at the end of the day, because whoever is going to come into this jurisdiction then has to mitigate for all the risks within the system, including that, you know, whether you want to call it judicial risk within the system.
All right, thank you so much. Thank you so much, Ma. You raised so many talking points. I'm not even sure which direction to go in, but I would have to go back to Mr. Ogundipe. I hope you can hear me. And the first point I would like to just highlight before moving on from Mr. Ogundipe is she spoke about lawyers being a problem, being the problem, the filing of frivolous applications. I think my question really would be, how did we get, I don't think we can deny that. I remember in 2019, I was fortunate to be part of a study conducted by the Lagos State Judiciary where we discovered that of about 3,000 old cases aged 5 and above. The delay was occasioned in those cases by counsel. I mean, I think it was over 66%, getting to 70%. And it was a survey that was carried out by actually looking at the court files and looking at why there was so much delay. We actually did identify that it was caused by lawyers most of the time, frivolous applications and so on. I think my question would be, based on that, how did we get here? Has it always been this way that counsel is more interested in taking the shortcut till the end by striking out the claimant's processes? Or was there a time when people were interested in the substance of the case? And how do we go past this problem, really? I think that's really the question.
Thanks. Hear me, because I keep getting this message that my internet. So I'm going to try and answer the question. First of all, it's not the lawyers. Okay? You can't blame the lawyers because all we do is the application. It is the court, the judge, who determines what that application is. And what is we have far too many judges who either do not have the courage or the knowledge, or maybe a combination of both, to address this problem. That's one thing. And then the second thing is that Mr. Oluwadare made the point. The judicial system, our system of law, is one in which the loser will suffer, in addition to losing, some financial consequences. If a judge finds that frivolous, the judge has the power only to dismiss it, not punitive costs, because you have costs normally they were taxed so that the successful party wouldn't get everything that they spent, so it's taxed. But you can have costs on a full indemnity basis, so that if the opponent's time, by having them engage in what is really a frivolous exercise, then all the costs that the opposing party has been put to should be reimbursed to that party. No court in Nigeria appears to have the courage to do this. It's just, if they do it, a great deal of the problem will be solved immediately. So don't blame the lawyers. We will do what we can when we can get away with it. It's human nature. So, you know.
Thank you so much, Mr. Ogundipe. The point is taken. Lawyers will do what they do if they can get away with it. The moment we stop getting away with this, then it will stop. All right, thank you very much. So I'm just going to move to my Lord Justice Oyewole. Would really like to hear from you now. And I'll just ask two questions really, and your Lordship can take his time answering them because a lot of issues have come up. So I think the first one for me is just to take the bench's view on Mr. Ogundipe's comment. You know, the bar says it's the bench. The bench has said, I mean, from the studies that have been conducted, said it's the bar. What is your Lordship's view in view of the position that Mr. Ogundipe has taken? That's one. Then I would say, what other factors, because we are not on the inside, what other factors your Lordship say inhibit the judiciary's performance, say from obviously what counsel puts to it? So the first one really would be, in view of Mr. Ogundipe's comment that judges need to do more to make sure that lawyers pay the price for their frivolous and bad faith practices. And then the second question will really be around the issue of what other non-apparent factors to us to Lordship think inhibit the justice system and the court system. Thank you, Lordship.
Thank you very much, Mr. Femina. Thank you, Alhaji Borodo, for your presentation. And I'm equally grateful to all the panelists who have spoken. Listening to everybody, for me, I was initially overwhelmed. Overwhelmed by the fact that I have been on the bench now for a little over 20 years. And at every stage of the way, I've been involved in a lot of reform, a lot of steps to make the system work. Then the question is, what are we not doing right? What do we still need to do to get to where we need to get to? Of course, when Mr. Oluwadare was speaking, I laughed a bit also because he probably wouldn't be aware of where we started from. For goodness sake, we had rules at a point in time when anybody would just file a writ of summons, go to sleep, later file pleadings. In the course of trial, you'll be bringing your documents piecemeal, litigation by stealth or whatever you call it then. We moved, and the first time we even moved, and initiated by the judiciary now, to filing written briefs, written addresses. There was a huge outcry. I'm glad Ms. Adekoya is part of this conversation. Mr. Ogundipe too will remember. Lawyers even went to court. This will kill advocacy. Why do you have to do this? People, for goodness sake, why must a judge sit down listening to somebody speak for 3-4 hours? At times, all you do in a single day is listen to a single counsel and you come back and continue making oral submissions. And the whole idea for us was, how do we shorten trial time? What do you do to ensure resolution of cases with minimal time spent on the cases, with minimal cost to the contending parties? We introduced alternative dispute resolution stages. Yes, when you get to a stage at a pre-trial, you go, you have opportunities to explore, but they always come back. Everybody wants their cases heard and determined. No system can make progress when every case filed must be heard. The capacity is never there. But what do we have here? First, apart from the lawyers, the system also has a lot of role to play there. If the lawyer wants to become a senior advocate, he has to show the number of judgments he had obtained. Contested judgments. If the lawyer wants to be appointed to the bench, he must produce the number of contested judgments he had been involved in. So the system itself rewards litigation, rewards contests, not resolutions. Again, for the judge, and I will go to some of the issues also raised, but I'm just giving this. I remembered, I think it was in my early days on the bench in Lagos, there was this case that was assigned to me, the case that spent about 28 years in court. Two factions of a church fighting. One faction occupied the premises, they built on it. They used to be a branch, and then they decided to move away from the mother church. And the case had been in court for 28 years. I looked at it, looked at the issues. The first time he came up, told all the counsel in the matters to stand up, raised the issues with them and told them, why is this here? Can't you all sit down and resolve this? By the time we highlighted the legal issues and why the whole thing had no business remaining in court, they agreed with me, went away, came back about 3 or 4 weeks after with terms of settlement. But we have a system whereby I got no credit for that because my returns to National Judicial Council will only reflect contested judgments, not cases resolved. Okay, coming back to some of the points raised. It is easy for anybody to talk about quality of judgment without also considering the enormity of work. If we look yes, we talk about the golden age when all the judgments of the appellate court, especially the Supreme Court, were so deep, were so detailed. But when we also look at that, we find out they were the days of the military. There were no elections. Now we have the 4-year ritual of election petitions. In between, you have pre-election cases. They are time-bound. So everybody leaves whatever they are doing to concentrate on this. Little time is left for the real disputes involving the ordinary people in the streets. There are systemic issues that we all need to look at. It is not the question of lawyers versus judges. It's the question of all stakeholders coming together. And this conversation that we are having today did not start today. Again, I can only speak for the judiciary where I worked, the Lagos State Judiciary. A lot was done back then, looking at the rules, working on the rules, but what do we find? The system also allows for interlocutory appeals. When the lawyer files an appeal, he tells the trial judge, I've transmitted record. Your lordship can no longer take this matter until my appeal is determined. For the litigant, all he knows is that his case has not been determined. We have lawyers who are out there seeking to develop the law at the expense of their clients. Also because they need all this to show at some stage either the privileges committee or whatever, how they have assisted in developing the law. We need, again, this conversation, if it's not just to be an ordinary talk show, must be retaken. This time around, having critical stakeholders available. What do I mean by critical stakeholders? Heads of court. I've had a lot of things said about filing processes, filing procedures, and all that. These are things where the heads of court could make changes, but they cannot make changes if they're not even invited to the table. Now, when we are talking about the issue of cost, again, I can give personal examples. When I was sitting at the commercial division in Lagos, it was very easy. I scheduled my trial. You have 2 days. I don't mind giving you 3 months, 4 months adjournment before your trial starts. But when I give you 3 days, you want to vacate any of the dates, I'll tell you. If whatever you want to do is worth 500,000 naira, you can take the date. Otherwise, the date stays. And in most cases, lawyers will agree and quickly stay and do their matters. Cost, definitely I agree, will assist us in managing cases. Now, something was said earlier about different things in different courts, the ability of courts or judges to manage their courts. Again, case management depends on individual judges. There's no rule of court, no matter how powerful, that will assist a judge if he is not master of his own court and is not ready to be creative in managing the courts. Of course, it's a question of space. As Mr. Ogundipe said, lawyers will always do what they need, what they can do, for as long as the space permits them, which also takes us to the issue. We need to regulate the conduct of legal practitioners. There are things we do in the course of legal practice in this country which we also know will never be acceptable in other jurisdictions. Again, because everybody believes you could get away with it. We need to come back. If we want this jurisdiction to be attractive to foreign investors, if we want the legal profession in this country to really tap into the market that is available for it locally and internationally, we all need to sit down and ask ourselves critical questions and look for solutions that will ensure that everybody does his part to make the system work. Thank you very much.
Thank you, my lord. It was very, very nice to hear from you. And I'm just happy. I'm a little excited with the way the conversation has progressed. We've identified common ground and we have a clear path on what the issues are. It's even more clearer now. I mean, it's a lot clearer than it was before. I'd like to still stay on your lordship for just a little more time. Your lordship did mention that he's been involved in reform for quite some time, since he joined the bench, if I remember. And this is something that we discussed behind the scenes when we decided to invite your lordship. We've heard from Justice Anna on all the work that's being done, and we know your Lordship has perspective on how much is being done. I think it's a good forum for us to share what has been done, so we know exactly, where to come in when we need to propose solutions. I mean, at GRP, our work is...
I'm sorry, I can't hear you now.
Okay, can your Lordship hear me? Can everybody else hear me, just to be sure? That's not my network.
I can hear you.
Yeah.
Perhaps it's Milord's network.
Okay,
yeah, I can hear you as well.
Okay, I think it's my Lord.
Yeah, I can also hear you, sir.
I can also hear you.
Thank you very much. So I'm just going to go to let me see if I can take Mr. Oluwadare while we wait for his Lordship to come back. So Mr. Oluwadare, I mean, the issues
I got the essence of the question.
Okay. Can your Lordship hear me now?
Yes, and now.
To stop the video, I'm going to try and just... I'm trying to get him back into the room. Okay, Mr. Oluwadare, let's just take your view on what can be done. I mean, we have the issues on ground. What can be done going forward? I think one area I'd like to highlight would be the issue of discipline for legal practitioners and how to keep us in place. I think Mr. Ogundipe and his Lordship have directed the conversation in that in that regard. So how would you say we go about keeping lawyers in place? And then what would you say are your solutions? What are your proposed solutions to fixing the problems with our court? So those two issues, how do we keep lawyers in place? And what are your solutions as a user of the justice, of the court system?
Thank you very much, Mr. Femina. I would have said if I was the one that had the login issues, I would have been afraid whether I've been banned from using Zoom, since I can't use Twitter presently. But since it's my Lord, I don't think that's the case. So to answer to your question, to say that lawyers need to be kept in, we don't need to be kept in our place. And so all this thing stems from the bar, really. Like I've mentioned earlier, even the bench, they are from the bar. So it means whatever we need to do starts from the bar. And I'd hinted that earlier, that it starts with legal education. Unfortunately, we all hear this every time, nearly every MDA conference. It's either about legal education or remuneration of junior lawyers, but nothing appears to have been done in either case. So the first thing I think would be the change in legal education. And this may come rather as a strange proposition, but I think this mentality of a noble profession needs to be set aside. Law practice is a business and it should be regulated as so. And you would see that that noble profession, while I'm not saying it's not a noble profession, that idea itself it would appear is an offshoot of the colonial aristocratic oligarchy mindset. But law business, law practice is a business and it should be regulated, taught and regulated as such. And it's not like businesses don't have ethics anyway, though they have their peculiar do's and don'ts. And so within this context, as law students, can we be taught that everything is input and capital into what you do? Your well-laundered white shirt, if you have enough money to keep it white at any rate, your transport to court, the A4 paper you print your processes on, and even your intellectual efforts, they are all capital inputs into the business. And these should be factored in and passed on to the paying client, of course, strictly regulated to ensure the quality of service. That itself will put legal practice in the right track. And maybe that would speak to what you said about keeping lawyers in their place. Now we understand what we are doing. We understand the business aspect of it. And of course, we understand that the cost when we step out of line. That would be a good way to start. Legal education as it is now does not bring forth the best, either in innovation or even ethics for the lawyer, because most of the ethics appear to be tilted towards being noble. But noble in what sense? Are we talking about being a pro bono lawyer or practicing his business while still understanding is what he must do? He must not step out of line, and the overall moral obligation that he owes to society. That would be a good place to start. And then to talk about the solutions to the problem in the judiciary as a whole, we've all seen the advocacy for judicial autonomy, but I think we need to underscore this point too, that judicial autonomy also includes a duty and a responsibility to be accountable on the part of the judiciary. And it's worrisome to see instances where the judiciary are listed as part of in the Auditor General's report. I've seen that in a couple of years now as those for financial infractions. And this is still without judicial autonomy, so to speak. So what that accountability process will mean is that it will ensure the continuous flow of the funds and the judicious use of those funds that will create a basis for the capital infrastructure that we need to use for administration of justice. So it means heads of courts will determine the kind of buildings they need, how much they need to build it, and as against where we see governors buying cars for judges and then they get applauded. These are public funds for public officers who are doing their best and should be rewarded naturally. And so that needs to be put in place. And that will bring, for instance, the practicality of the fit for purpose that we need. And I would expect, for instance, to give this context, that stakeholders like court staff, lawyers, and the public are consulted by the contractor who is designing and building a court, for instance. It would not be proper to build a court, for instance, where you have to go to the ground floor to assess what they call assess your processes, and then go to the 6th floor to pay, and then you go to the 7th floor to stamp. So you understand why this will bring the touts will come to the court who will tell you, just sit down, give me and I'll sort it for you. And so these are all those practical things that would come with real judicial autonomy. And then innovations. I think innovations need to be spearheaded by possibly the NJC or Council of Legal Education or whoever regulates the educational arm and then the practice. Again, I align with what His Lordship had said about administration of courts being essentially being individual. But we need processes and innovations that would at least set the stage, and then these things flow downwards and they become norm with the adaptation by each judiciary at the states. Then lastly, I would like to point out the training of judges. And I think this should not be limited to legal knowledge, as it were, which I think they get enough from the courts. And the quality of judgments, I don't think it's bad. It's about the understanding the environment. And that's why you read judgments, you see holdings of court, and you're like, is this judgment from Canada? Like, this is Nigeria. We know what happens there, and this is what this judgment should be about. So training of judges should mean exposure to the trends in the socioeconomic environment and the norms of that environment where we live. As funny as it sounds, in my own experience, it is always frustrating in court to explain to the judge why freedom of information is public interest, really. And I get to do that with almost every suit. I get to defend why what I'm filing is in the public interest. And so that means that judges need to be exposed customarily to not that narrow legal knowledge, but even the social nuances of the environment that they live, the practicalities of what goes on around them. So when a lawyer asks for cost, for instance, it's not to give him a pittance, really. He's asking because he has suffered something for coming to court for a preset date, for a preset purpose, and that purpose hasn't been met. So when you now give that lawyer 2,000 naira cost, really, he has just told you his office from so. These are the dates, the costs he has incurred. So the question is, if you understand the value of what he has gone through, what will 2,000 merit in that instance? Thank you very much, Efemina.
Thank you so much, Mr. Oluwadare. Before we go back to my lord, or Mr. Ogundipe and my lord, I'd like Mrs. Jagun to just speak to her own proposals for the justice, the court system. I know we spoke about technology. We did mention how technology could play a role, and you seem to have some interest in that regard. So we'd love to really hear you speak. Thank you, ma'am. Yes,
thank you very much, Efemina. And before I go on to speak about technology and what can be done in that area, especially because there is limitation in terms of resources. I think this is an area where collaboration is key, and this is an area where collective action, the private sector, the business sector, working with the judiciary, working with the bar can really help in just kind of like updating to the technological platforms, building fit for purpose technological platforms and systems, and being able to assist in that area. I think there definitely needs to be a lot of collaboration in that area. There are times when, for instance, we have quite a lot of these technology hubs, and we have young people who are developing applications and technological platforms that are being used by the banking sector and other sectors. And I think it's really being able to tap into that, tapping into the wealth of the young people we have to come in, identify where the blockades are within the system, and being able to design and develop something that is not only going to be fit for use in Nigeria, but something that can also be exported internationally as well. We have a lot of resources in Nigeria, and we need to be able to take advantage of those resources and maximize them and make them work for us. So I think really working with the business sector, a lot more needs to be done. Even in terms of training, there's a lot of training that is unique to, for instance, when we talk about oil and gas, when we talk about capital markets, when we talk about mergers and acquisitions and certain types of transactions that are quite not very straightforward. I mean, they're quite complex. When things go wrong, we need judges who have a real understanding of the structures that have been put in place, and not just an understanding of the law. And so I think, again, this is an area where law firms who help structure these deals, who help structure these transactions, can deliver training, not just to lawyers, not just to their clients, but even bringing in the judiciary. I mean, this is something we do as a business. We found that, for instance, the journalists don't really quite understand the nitty-gritty of some of the things we do. We bring them in when we have trainings, and we get them involved, and they have a better understanding, and are therefore able to better report on what is happening within the sector. I think also the use of more use of pretrial, and the use of pretrial conferences, the use of judicial commissioners drawn from the law firms on an ad hoc basis to deal with certain commercial disputes, I think is useful. Maybe that can be a criteria for sanship, rather than being able to evidence the fact that you have done so many contentious cases in court as a criteria for sanship. But in terms of technology, I really feel that it is an integrated approach is needed, and that we do have a lot of resources that we're overlooking at the moment, and a lot more collaboration with the tech hubs, with tech startups, infused with support from the private sector. We have Google in Nigeria, we have Microsoft, we have all of those technology companies. And of course, we have our local technology companies as well that are rising up. And then the business sector, who are beneficiaries or recipients of, or will be, as well as the bar, who will be beneficiaries of a more efficient system that allows for electronic filings, that allows for, just being able to search for judicial decisions online, being able to access your decisions online. All of those type of things are in our best interest. And so a collaborative approach is needed. Thank you.
Thank you so much. Thank you so much. Mr. Ogundipe, before we go to his lordship, is there anything you'd like to add in terms of solutions and what can be done?
Thanks, Efemina. If you pardon me, I haven't banged this drum for a long time. So it's been such a long time. I think that I can do it now because, I'm so far over the hill that it doesn't make any difference. Ms. Jagun mentioned SAN and the rank, attaining the rank. I just want to bang on this drum for a while. That rank is a reward for the volume of work that a lawyer does and not for the quality of the work the lawyer does. More than 25 years ago, I have been advocating for the abolition of the rank. At the very best, be reformed. It is something that is in the gift of the incumbent Chief Justice of Nigeria. The legal profession is independent. The bar is meant we be independent if the incumbent Chief Justice of the Federation has a gift he can give, because he is the one responsible for populating the committee, primarily responsible for populating the committee that makes the decisions. Why should he have that ability? Because of the individual lawyer. Justice Oyewole has mentioned the fact that, many people have said it, that the volume, a lot of the volume of the caseloads in court is people aspiring to that rank and pursuing appeals where they are devoid of merit, where the issue has been long settled, but just to get something that you can take to the Privileges Committee and say, I was involved in this thing. I have people, I know people my age last year or a couple of years ago. I had to tell him, I said, at this stage of your life, why are you running around Nigeria looking for this gift? You don't need it. It's not going to enhance your profession, because you attained so much and people respect your professional ability. This chieftaincy title that gets conferred on you, you don't need it. It's not a rank that denotes quality. That's enough. What can be done? Again, I come back to commerce, economics. When I was a student, I didn't know anything about economics. I didn't know anything. I couldn't subtract. But as time has gone on, I've come to understand that every single thing in the world is dependent on economics. If you don't to pay for stuff or to generate income to pay for stuff, then there's very little you can do. What we should be thinking about is focusing on understanding what the needs are to improve the sector and looking for means to generate the funding that's necessary. That's, I think, really, really important thing. It's economics.
Thank you so much, Mr. Ogundipe. Thank you so much. Can my Lord hear me now? Because we'll take your Lordship.
Yes, I can hear you very well. My
right.
Apologies. I had to quickly change the source of my internet so that at least I can be back online.
No problem.
I apologize for the...
No problem. Thank you. Thank you very, very much. So we'll just take, this is the last question we're going to take before we now take views from the audience. I know some people have been itching to speak. So I think really, now that we've heard the solutions, I guess we'll just end with your Lordship telling us, so far so good, what it looks like. What does your Lordship personally think, can be done, and so far so good, how much progress have we made? I did mention that Justice Zana had shared some developments with us and things that we hope can go around. But we'll just appreciate your Lordship's perspective on the reform work he has done, your Lordship has done, and obviously solutions your Lordship will propose going forward. Thank you, Your Lordship.
Thank you, Femina. I think the first and most important thing is for legal practitioners to even look at our rules and work with those rules. What we find out is that we are quite advanced, or let me put it better. The way Because when you're talking about rules, you are talking of something that is totally within the purview of the judiciary. And the rules, we keep on looking at them regularly to update them and make them more beneficial to the system. But what we find out is that legal practitioners don't like change. Most of the time, they don't even look at the provisions to maximize what they contain. For instance, the 2016 rules of the Court of Appeal allows legal practitioners to serve applications by email, by electronic means, not even by email, by electronic means, specified including by text, by all this. In other words, you file your motion, you scan it, send it to your learned friend, send it to his email. It's been there since 2016. How many of our lawyers do this? They get to court, I couldn't serve. Oh, a bailiff went there. They did not meet it. And because of that, there has to be an adjournment. And of course, the litigant puts that at the doorstep of the judiciary. They've been wasting my time. They are delaying my case. So I would say the first and most important thing, we need to familiarize ourselves with the rules. That is one. For bodies such as JRP, you need to move closer to the judiciary. I've heard comments being made about Council of Legal Education. For goodness sake, there is the National Judicial Institute, which is responsible for continuing education of judges all over. Programs such as this, when you move closer to them, you will understand quite a number of the things they have. And technical organizations, when I mean technical organizations, like the Shippers Council, partners with the NJI, because that's a specialized area of practice, to bring judges up to speed about what obtains in their field. You find bankers committee doing something similar in the banking area. So what can be done in terms of continuous education is limitless. And there is a body working on that. There is a body established for that purpose. But again, we keep going around in circles discussing when we should be working on activities that will actually help to make the system better. I think we should go beyond conversations. I think we should really put our hands to the plow. There's so much there is to be done. I know the Court of Appeal is even looking at the 2016 rules as we speak to make the rules better. The judiciary does not go about addressing the media on what it does. It is only the bar that speaks for the bench. During the last Jusen strike, so much offense has been made to it. Cases were heard, appeals were heard, not just by the Supreme Court, by the Court of Appeal. So many judgments were delivered by all levels of courts. Again, these were not captured because most of the cases involved were not sensational cases or political cases that will be reported in the media. But litigants were actually satisfied having their cases determined even while the strike was on. Again, this was not captured anywhere. Now, I will say, whatever needs to be done must be total. We need a reform of the rules. Constitutional review is going on now. Submissions must be made to the National Assembly. No system can make progress when everybody and anybody can appeal any issue. We've had ridiculous interlocutory appeals. When all you need to do is wait for the case to be concluded. Whichever way, the tree will fall somewhere. You have lost the battle, you may not even lose the war. But what do we find? Needless interlocutory appeals going up to the Supreme Court, sometimes 2-3 times in the lifespan of a case. That needs to be regulated constitutionally. We cannot allow that if we are to make progress within the system. That does not depend on any individual judge. That goes beyond what a chief judge or even the chief justice of Nigeria can control. Of course, we also can address the issues about case management. I can assure you NJ, National Judicial Institute regularly organizes programs on case management, on developing the abilities of trial judges to manage their courts, on the abilities of trial judges to do their work better. It is a continuous exercise, and it goes on. Even during all this lockdown period, programs have been going on virtually to ensure that trial judges are equipped to do their jobs in the best way possible. I will only say that this conversation needs to be brought closer to those who can take decisions. These conversations need to be upgraded to the level of partnering with the relevant bodies to actually deliver on needed changes. And that ultimately, if the legal practitioner, if the legal profession itself is not to find itself in the same way with engineering and architecture, everybody must realize that we have a role to play in what is before us. Thank you very much.
Thank you so much, Your Lordship. Thank you so much. And I want to thank all our panelists. And again, Your Lordship, Justice Olubunmi Oyewole, Mr. Ayotola Jagun, Mr. Babajide Ogundipe, and Mr. Kolawole, Oluwadare. Also like to thank Alhaji Tijjani Borodo for his address, which set the tone for all these discussions. So now we'll take comments and questions and views from the audience. It's an open conversation. We have the next 18 minutes to get this going, maybe an extra 5, just so we can take as many views as possible. And then we'll close. So if you have a comment, a question, you can raise your hand, and I will call participants in the order in which the hands reflect on my screen. So yeah, the rules are simple. We should stay muted while someone else is speaking, and we should keep our comments as short as possible. Okay, so we have a hand up, and that is from Mr. Pampa. Mr. Pampa, the floor is yours. We have 2 minutes for that, maximum.
Thank you so much. Mine is very simple. I want to thank the all the speakers for the very enlightening conversation that we've had. And I want to thank His Lordship especially for the direction in which he has pointed us in order to make these conversations more impactful. Thank you.
Thank you, Mr. Pampa. You've left us with 1 minute and 44 seconds to spare. So thank you very much. Alhaji Borodo has his hand up, our keynote lead discussant. So sir, you have the floor now.
Hello, thank you very much for the opportunity.
Thank you.
Once more, I must thank you for the opportunity to be part of this. And I'm just taking a cue from what His Lordship has said, that this forum, we should synthesize the issues raised and make them into actionable points and start going to actioning things. There are several things that we can take out from this discussion, put them into actionable points, and let's see where do we go to start making them a reality, so that at the end of the day, the business environment will have better confidence and trust in our judiciary. These are my comments. Thank you very much.
Thank you very much. Thank you very much. We have 1 minute and 19 seconds to spare, so thank you so much for keeping the time, Alhaji Borodo. I can see the name is Nenga Shiwa. I hope I pronounced that well.
Thank you so much, Femina, for the opportunity. My name is Nenga Shiwa from Accountability Lab, Nigeria. Yes, and from our end, I think our concern will essentially be about, just like Oluwadare mentioned earlier, about the accountable nature of the judiciary itself and how this has impacted on justice delivery. Because to a layman on the street, his understanding of an effective justice system is when justice is delivered as delivered timely, and even if he lost in the process of whatever that verdict ends up being is well understood to him. And to add to this, also be the issue of integrity of the judges. and actually even that of the bench itself. I mean that of the bar, because when we have people who begin to file in frivolous applications and all of that, and then judges, we also understand a number of times have been compromised for a number of reasons. This brings down the level of discourse and the justice system generally to a low ebb. Finally, and importantly too, just like His Lordship mentioned, I think this discussion is apt, but it needs to be more inclusive, where we can have more partners coming in, especially those who have the capacity to make decisions and relevant bodies who have the capacity to make important input, so that we can have the kind of justice system that all of us can sit back and admire. Thank you so much.
Thank you so much, Nenga Shua, for that contribution. We don't have any hands up anymore, but is there anybody with anything to say? There's a comment in the chat box. It says, this topic needs to be more and more emphasized. My view, enhancing the justice system is a collective effort of both the bar, the bench, and litigants. We should continue to put policies in place to enhance the system. Thank you very much, Dema Dibi, for that contribution. Do we have any other hands up? We have quite some time. If not, we can close, but it would be nice to get your views. It's a conversation, open conversation for a reason. Okay, Mrs. Adekoya, our chairman.
Good evening, everyone.
Good evening,
mine is a comment of sorts. And really it is to thank all those who have joined and to ask you to please tell us the ways in which you think we can make the justice system work for all. We've heard, at least I've heard, some intriguing contribution, especially from Justice Oyewole, from the perspective of the judiciary. For those of us who are advocates before the courts, we have always taken the view that the submission of written briefs has not helped the advocacy process. And that is because you find out that when you get into court at the adoption stage, perhaps because of the caseload of the individual judge, what we are told is adopt your brief, adopt your brief. And there is very little oral advocacy. In fact, oral advocacy is probably restricted only now to cross-examination in the lower court. Perhaps what could help is if there is a possibility that at the time the counsel come to adopt their briefs, especially in the appellate court, that the judges actually interview the counsel on the basis of their filings. One, because it gives the counsel confidence, and also the clients, if they are present in court, that the judges have read the briefs and understand the issues that are raised. Especially in international transactions, I've had cause to assure clients that the judges will read the briefs. And the fact that you're only there to adopt does not mean that they have not read it beforehand, even though possibly sometimes we doubt whether they have read it beforehand. Perhaps this is something that would ameliorate this issue of submission of written briefs. I am sure that a lot of lawyers would even become more involved in preparation of their briefs if they have an expectation that when they go to adopt, judges would actually ask them questions referring to paragraphs of the brief to indicate that they have read it, they need clarification, or is this the position that they are advocating? So that's one thing that might perhaps be a meeting of the minds between the practitioners and the judiciary. The other thing that I would like to say as well, listening to the users of the system, is we are looking at holistic justice reform. And so litigation is not just, it's just one of the streams. And so to those who are the users of the system, it might also help if before going into court, the pre-dispute resolution processes are thoroughly examined, settlement by mediation or negotiation. Sometimes the pre-action protocols that are required to be filed, to my mind, is no evidence of having made any serious attempt to settle the dispute. It's more a question of, well, this is my demand, and if you don't pay within 7 days, I'm going to court. Perhaps a more serious attempt to settle a dispute would be an offer to discount interest on a debt or to propose instrumental payment of the debt in full. And this might actually lead to a discussion that would keep the matters out of the court. I could go on and on, but I'll leave it for this. If any of the attendees have any issues that they would like JRP to look at or that they feel would enhance the delivery of justice to the users of the judicial system, please do not hesitate to contact the Secretariat with your thoughts and your ideas. Thank you.
Thank you so much, Mr. Adekoya. Thank you so much. I saw Mr. Ogundipe's hand up, but I'm not sure if his hand is still up. Okay, Justice Oyewole has his hand up. My Lord, yes.
Thank you very much. Let me start by saying it's very nice seeing Mrs. Adekoya again after quite a long time. We know that it will take a lot of money to bring her to jurisdictions where some of us now operate. But the point she made about whether judges actually read briefs, I can assure you, not only do we read briefs, we read every page, every line of the records. I can assure you about that. And in jurisdictions where I am, quite a number of times you find yourself even helping lawyers formulate their issues properly. You find lawyers not even understanding their own cases or being lazy about it. Somebody will tell you he has 10 grounds of appeal and he just goes 10 issues, one from each of the grounds of appeal. Repetitive issues, which shows that he himself does not even understand his case. We do a lot of that. Be rest assured, we also do conferences. We discuss these cases before judgments are written. A lot, which is why when people talk about sittings constitute barely 20 to 25% of the work of judges. The bulk of it takes place outside the courtroom, in the chambers. It's important for JRP, and I'll keep on saying that, to move closer. Again, Alhaji Borodo mentioned issues about judges writing a long hand. Again, one can only smile. For the last 10, 12 years that I spent in Lagos, no, the last 10 years I spent in Lagos State Judiciary, I never had cause to write anything by long hand. There were transcribers that were recording the equipment in my court. I never had any cause to write. Sit back and listen, make jottings. That's all we did. So things are actually moved, but again, we don't have a single judiciary in Nigeria. There are 36 state judiciaries, 37 actually, including the FCT, each with varying degrees of development. There is a need to engage stakeholders properly. Look at what needs to be done in each jurisdiction that will assist to get us to where we need to get to. Thank you very much. It's been a wonderful opportunity to be part of this conversation. And I keep on saying it. I wish we'll take it further to get the system to really benefit from the desired change. Thank you very much.
Thank you, Your Lordship. Thank you very, very much. Mr. Agubame, SAN, has his hand up. We can see you.
Effemina, thank
now
you
we
very
can
much.
hear you. You're welcome.
I know you've taken time to learn how to pronounce my surname, and you took time, and you did well.
Thank you very much.
Okay, let me continue from where Mrs. Adekoya stops. Mrs. Adekoya has asked us to, has asked the platform, those on the platform, to kindly contribute by suggesting areas where they believe that we could be of help and intervention as JRP. I want to turn that around slightly. What we do with the administration of justice and why we do it must be subject to constant review. Therefore, for all those on the platform, I would be saying that it's not just a matter of suggesting. The prescriptions are quite clear. Mr. Ogundipe has been talking about abolition or reforms of the SE, and what he says is correct. What everyone on the platform says is correct. We know what is wrong. We have prescription. The question is, how do we implement this change? So we need people to contribute their time, contribute their resources towards this reform. So really, maybe Femina will be doing that before we close. I just wanted to support Mrs. Adekoya. It's not only a question of suggesting to us what we should do. I'm going to be calling a number of people to contribute something, if it's funds in respect of a particular project we're picking up, or if it's your technical expertise. Justice Oyewole, perhaps I'm going to contact you offline because there's some reforms that are going on. I would like to hear the judiciary's view. Ayotola, Jagun, I'm going to come to you to put together all the company secretaries for support in various areas where JRP is thinking of intervening. And I'll tell you some of the challenges we're facing. So my own contribution really is to act as an ambassador for JRP and ask you to please respond positively when we approach you. Thank you very much.
Thank you very, very much. Thank you so much, Leonard Silk. I can see there's a hand up. I'm not sure whose hand that is. Okay, I think it's still your hand, Leonard Silk. So while we wait for the next hand to come up, I will just take time to toot our horn a bit to just share what JRP has done in the past year or so. So we try as much as possible not to just talk. JRP has very busy members, but we try as much as possible to get on the road and do what we need to do as much as possible. I mean, after there was the outbreak of COVID, we had to write several letters to the NGC asking to consider virtual hearings, remote hearings to the NBA. And thankfully, after these letters were written, whether it was by reading letters or not by reading letters, you know, the NGC did take the step of passing the practice directions. But more importantly, and it's a point that would interest His Lordship, Justice Oyewole, we partnered with the Lagos State Judiciary to organize a full virtual hearing. We did trials, we did an interlocutory hearing, we had a ruling delivered. All of this is available on the JRP's YouTube channel. Save for the coronavirus and the pandemic and what is done, the plan was to go around as many states as possible, interacting with the judiciaries, with the other players in the justice sector to see how we could assist in immediately offering help and assistance in bringing reform. So this is part of what we do. We've also done quite a lot. I know we have a bit of an agreement in principle with the Council of Legal Education on ethics and amongst other things. Before I go on and keep rambling, I have a hand up. Mr. Akinlade, who's also a part of us, has his hand up, and I think you'd like to say something. So Mr. Bayo Akinlade. After Mr. Akinlade, we'll take 2 more comments, then we would close. Mr. Akinlade, we can't hear you, but I can see your hands up and your mic is on. Hello? Okay, I still can't hear you. Can everybody else hear me, just to be sure, because I need to be sure I'm not the one who's not being heard.
We can hear you.
Yeah, I can hear you.
All right, thank you very much.
Yeah.
Mr. Bayo, if you type your suggestion, I will read it out if the problem is not being able to speak. Until then, any other comments, any other suggestions? It's an open conversation. So when next we put out the next flyer, you should be prepared to come and, you know, make comments on what's being said here. It's very important that we take your views. Also, to add to what Mr. Ogundipe did say, we are going to put out a report of this event, and we're going to look into how we can get volunteers to come and support some of the initiatives we have based on the issues. Some of the initiatives will commence based on some of the issues raised here. if you need to reach out to the Secretariat based on Mr. Adekoya's suggestion, you can just send me an email. Through the emails, I sent the Zoom link to you. Mr. Akinlade, or is there anybody else with comments? All right, I don't see any. I would assume that Mr. Akinlade is typing his, once his comment comes in, we'll just close. Okay, so his comment has come in. I would just like to emphasize the need for us to work together to improve the justice sector. Thank you so much, Mr. Akinlade. And now I think we're just going to close because we're getting to the end. I'd like to thank again everyone for coming. My Lord Justice Oyewole, our panelists, the Keynote, Alhaji Borodo, the chairman of the Justice Reform Project, Mrs. Olufunke Adekoya, the convener who was there, Mr. Candy Johnson, Mr. Astaro Ehuberman, Mr. Babajide Ogundipe, and everybody present really. I don't want to miss out any names, but if I keep going on with the names, I'll have to read everybody's name out. I'd like to thank our partners, Integrity Organization. They provided the technical support for this, so the Zoom is entirely on them, even though we have ours, but they've done a lot to assist with this. I'd also like to appreciate ProShare for providing support with the speakers we have today, Mrs. Jagun, Alhaji Borodo, and Mrs. Jagun and Alhaji Borodo were recommended by ProShare, so I'd like to just say thank you. Before we close, I'd like to call on Mr. Pampa. I don't want to put you on the spot, but I have to, just to say a few things, since he's the lead of our partner organization. Then after that, I'd like to also put Mr. Adekoya on the spot. My apologies, just to give closing remarks. So Mr. Pampa.
Thank you very much, Femina, having put me on the spot. We are very grateful, really, for having this conversation today. It's always very difficult to get professionals, especially lawyers, to do the right thing and to do things right. When you speak to many lawyers, it's as though you've come from another planet when you start to talk about ethics. We know it doesn't apply to everyone, and we know that it doesn't apply to the whole sector. So how do we get the sector working in the best interest of the users, the ordinary person on the street? This really is what has attracted us to JRP, because we believe JRP is on a mission to try to reform the sector in the way that the justice sector works better for everyone. And for this, we will continue to lend our support and to lend our voice. So thank you very much to everyone who made it here today. Thank you.
Thank you so much, Mr. Pampa. Our chairman, Mr. Adekoya, would like to get your closing remarks before we round this up.
I have no closing remarks other than to do what has already been done and to thank all those who have taken their time out today to participate in today's event. I note that one of the comments has been on the reform of the probate system, letters of administration, which take forever. And I think that this is one aspect that the Justice Reform Project will have a good look at. And it might be perhaps the subject of one of our next conversations. Thank you very much, everyone, for being able to join us this afternoon. And please, even though this session ends, do not hesitate to get in touch with your thoughts, suggestions for reform, and areas that you think we should look at. And if you're around in October, please join us, Aro Egobamian, in his run for justice. Thank you.
Thank you very much. So we'll now close. Do have a lovely evening, everyone, and have an even better weekend. Good night.
Thank you very much. Bye.
Bye.
Thank you.
Thank you very much. Thank you. Goodbye.